In America, police generally need probable cause before they can arrest you. But in 1968, the Supreme Court confronted a harder question. What if an officer believes something dangerous is about to happen, but doesn't yet have enough evidence to make an arrest? Can he stop you anyway? Can he search for a weapon before a crime has actually been committed? That case was Terry v. Ohio, and it changed everyday policing in America. The story began on a street in downtown Cleveland. A veteran police detective named Martin McFadden was patrolling a beat he had worked for years when he noticed two men, John Terry and Richard Chilton. The street didn't feel normal. Over the next several minutes, they circled the same storefront roughly 24 times, walking past, pausing to peer inside, returning to confer with each other. At one point, a third man joined them briefly, then left. To McFadden, this wasn't shopping. It looked like preparation. He believed the men were casing the store for a robbery, but belief is not the same thing as proof. He had no warrant. He hadn't seen a robbery. He hadn't seen a gun. He did not have probable cause to make a full arrest. What he had was suspicion, so he followed them. When they rejoined the third man a short distance away, McFadden approached, identified himself as a police officer, and asked for their names. The men mumbled a response. Then McFadden grabbed Terry, turned him around, and patted down the outside of his clothing. In Terry's overcoat pocket, he felt a gun. He ordered the men into a nearby store, removed Terry's coat, and recovered a revolver. He found a second gun on Chilton. Both men were arrested and charged with carrying concealed weapons. At trial, Terry's lawyers argued the gun had to be excluded. The Fourth Amendment protects people against unreasonable searches and seizures. If McFadden lacked probable cause to arrest Terry, how could he legally stop him on the street and search his clothing? The trial court disagreed. The gun stayed. Terry was convicted. The case went to the United States Supreme Court. The question before the court was not whether policing is dangerous. It was not whether McFadden had acted in bad faith. The question was narrower and far more consequential. When does a street encounter become a constitutional search and seizure? And what level of justification does the Fourth Amendment actually require? Chief Justice Earl Warren wrote the majority opinion. The court began by rejecting a convenient fiction. A police stop is not nothing. When an officer restrains someone's freedom to walk away, that person has been seized. When an officer pats down clothing to feel for weapons, that is a search. The Constitution follows a person onto the street, not only into homes, not only into courtrooms, not only after a formal arrest, but the court did not stop there. It also held that the Fourth Amendment does not always require probable cause for every brief street detention. Officers sometimes face fast-moving situations where waiting for full probable cause could put them, or others, in danger. Evolkamation, Amowo rule. If an officer can point to specific and articulable facts suggesting criminal activity may be afoot, he may briefly stop the person to investigate. And if he reasonably believes the person may be armed and dangerous, he may conduct a limited pat-down of outer clothing to search for weapons. Not evidence, not drugs, not whatever he might hope to find. Weapons only. The purpose of the frisk, the court said, is officer safety. That distinction became the heart of Terry v. Ohio. A stop is not the same as an arrest. A frisk is not the same as a full search. And reasonable suspicion is a lower bar than probable cause. The court ruled 8-1 against John Terry. Detective McFadden had observed enough unusual behavior to justify the stop, and enough reason to fear the men might be armed to justify the frisk. The guns stayed in evidence. The conviction stood. Only Justice William O. Douglas dissented. In his view, the Fourth Amendment demanded probable cause before the government could seize and search a person. Anything less, he warned, gave police more power than a judge could authorize. That warning did not become the law. Terry did. The phrase "Terry stop," a brief investigative detention based on reasonable suspicion, became a permanent part of American policing and constitutional vocabulary. For supporters, the decision gave officers a necessary tool to prevent violence before it occurs, recognizing the reality of street policing where danger can appear before a case is fully built. For critics, it opened the door to aggressive stop and frisk practices, especially in communities already under heavy police surveillance. A rule designed for a limited weapons pat-down became, in practice, a broad authority to interrupt ordinary life. That is why Terry v. Ohio remains controversial. The case did not say police can stop anyone for any reason. It did not say a hunch is enough. The officer must be able to explain the specific facts that made the stop reasonable. But Terry also lowered the threshold. It allowed police to act before probable cause, and that shifted the balance between public safety and personal liberty. The facts were small: 3 men, a store window, a detective watching from across the street, a pat-down, a gun in a coat pocket. But from that encounter came one of the most important Fourth Amendment rules in American law, and a question that still doesn't have a clean answer. How much of your freedom should you lose before the government has enough proof to arrest you?